Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to introduce the concept of Labor Standard Act. That means basic understanding of Labor Standard Act. How we understand in labor law, especially Labor Standard Act. So, there is a general provision that are about each chapters. But first chapter is general provision. It explains about what is the Labor Standard Act, how it can be implemented in actual related law. This is how I can explain. So the the Article 1 of the Labor Standard Act, it is a purpose. So actually this labor standard is originated from Constitution, especially Article 32 paragraph 3. It stipulated working conditions shall be stipulated in law in order to make sure human dignity. So based on this guideline, Labor Standard Act was established. So the purpose of this Labor Standard Act is to provide the basic working condition to make sure of their basic living the standard. That is some definition or the purpose of the Labor Standard Act. So the Article 3 it explains the condition of Labor Standard Act. This is kind of most basic or minimum or compulsory working condition. If employer violate this compulsory basic condition, then employee will be charged for criminal the violation, because there is, each article has a penalty provision. So there is a labor inspector that who is a kind of labor police. They take care of this. They make sure of the implementation of Labor Standard Act. So because any violation has a penalty provision, then labor inspector, they have police power to implement this compulsory law. So also Article 4 of the Labor Standard Act, so it shows the how to make a working condition. So this condition should be made decided by mutual the agreement on equal footing. So this concept is important. So every working condition should be made in writing based on mutual agreement. So this means employee cannot make a working condition unilaterally. If labor union, the employer changes working condition the one-sidedly or unilaterally, then this condition is not valid. So such a condition is, for example, if employer reduced certain working condition without there is for example, severance pay. So when employee served 1 year, 1 month is entitled additionally for their later salary is we call it severance pay. But certain company, they provide 2 months salary for each service year. But employer without receiving the collective agreement from majority of workers, employer changed the working condition unilaterally just from 2 months salary for each service year to the 1 month. Then this is disadvantage, this unfavorable change. So in that case, it's not valid, because working condition should be decided on mutual agreement. So this is a really right concept. Also Article 5 explains, so employer and employee must follow the Labor Standard Act provisions. So each party violate, then they will be punished by this Labor Standard Act. Also, Article 6 of Labor Standard provide equal treatment. There should be no discrimination against gender, also against nationality or against religion or social status. It explains the employer cannot discriminate employee based on those conditions. If employee violate this condition, then discriminate the employee because of those items, then employee will be punished for this violation of this Article 6. Also, Article 7 or 8, it deal with there should be no like forced labor or some like violence or some abusing employee using their superior authority. Also, Article 11 explains some application of Labor Standard Act. So the employee that hired 5 workers or more will apply to all working conditions of Labor Standard Act. So some employee who hired less than 5, then still they are applicable to working conditions like wage payment or basic. But some articles they are applicable to the employer who hired 5 workers or more, like dismissal or some overtime rate, overtime payment or annual paid leave. Those are some additional. There are some application for those who hired 5 or more. So finally, this Labor Standard Act is applicable to the territory rule. The all entity, the inside of Korea, they are all applicable to Labor Standard Act. That means it applies to the principle of territorial rule, territorial application. This means like the employee provide the labor service in other country to Korean company. They are now applicable to Korean labor law. They are applicable to the local country's labor law. But any foreigners or any entity located in Korea, the workers working there, even regardless of their nationality, they are applicable to Labor Standard Act. Okay, this is the basic concept how we understand of Labor Standard Act. Okay, this is all. Thank you for watching. Bye bye.